Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying this content, please remember to subscribe. For today's video, we have United States of America versus Martinez-Fuerte. This is a case dealing with an immigration checkpoint, but one that is not at the border. This is one that is just on a highway somewhere away from the border that they have a permit set up immigration checkpoint, and they are conducting searches related to finding potential illegal immigrants, but not at the border. And some people are suing in this case, dealing with whether or not this is an illegal search. They're being potentially detained, potentially searched, even without any kind of articulable suspicion, and whether or not that's proper. So we're going to learn whether or not the United States government can have immigration checkpoints just, like wherever, not particularly at a border, not particularly at an airport, not particularly at a seaport, but just, in the middle of a highway, away from the border for no particular reason. Let's get started with this. The respondents in this case are defendants in 3 separate prosecutions resulting from arrests made on 3 different occasions at a permanent immigration checkpoint on Interstate 5 near San Clemente in California. Interstate 5 is the principal highway between San Diego and Los Angeles, and the San Clemente checkpoint is 66 road miles north of the Mexican border. Okay, so we have this immigration checkpoint on Interstate 5 between Los Angeles and San Diego, and the checkpoint is 66 miles north of the border. So it's just a checkpoint on the interstate that's there, and it's a permanent immigration checkpoint, not near a border, which seems a little odd. So is that a thing the government can do? The point agent, standing between 2 different lanes of traffic visually screens all northbound vehicles, which brings the checkpoint to a virtual, if not complete, halt. So the way this operates is that there's an initial officer who stands between the traffic, who inspects the vehicles and brings the traffic to a stop. Most motorists are allowed to resume their progress without any oral inquiry or without a closer visual examination. In a relatively small number of cases, which, in the grand scheme, sure, but if you're doing 1%, that's still a lot of cars. In a relatively small number of cases, the point agent will conclude that further inquiry is in order. He directs these cars to a secondary inspection area where the occupants are asked about their citizenship and their immigration status. So they're being detained because the point guard thinks that they should be inspected 66 miles north of the border. We turn now to the particulars of the stops that were involved in this case and the procedural history of the case. The respondent, Martinez-Fuerte, approached the checkpoint driving a vehicle containing 2 female passengers. The women were illegal Mexican aliens who had entered the United States at the San Ysidro point of entry by using false papers and rendezvoused with Martinez-Fuerte in San Diego to be transported northward. At the checkpoint, their car was directed to the secondary inspection area. Martinez-Fuerte produced documents showing him to be a lawful resident alien, but his passengers admitted to being present in the country illegally. He was charged, among other things, with 2 counts of transporting illegal aliens. In a related case, Jose Jimenez Garcia attempted to pass through a checkpoint while driving a car containing 1 passenger. He had picked the passenger up by prearrangement in San Ysidro after the latter had been smuggled across the border. Questioning at the secondary inspection area revealed the illegal status of his passenger, and he was charged with also, among other things, illegally transporting an alien. We are concerned here in this case with permanent checkpoints, the location of which are chosen on the basis of a number of factors. The Border Patrol believes that to assure effectiveness, a checkpoint must be distant enough from the border to avoid interference with traffic in populated areas near the border, which it seems to be interfering with traffic, so not so much on that one, but okay. Close enough to the confluence of 2 or more significant roads leading away from the border, situated in terrain that restricts vehicle passage around the checkpoint, on a stretch of highway compatible with safe operation, and beyond the 25-mile zone in which border passes are valid. So the Border Patrol has a whole bunch of criteria for where they set up a border checkpoint, and apparently they thought this was a good spot. It is agreed that checkpoint stops are seizures within the meaning of the 4th Amendment. The defendants contend primarily that the routine stopping of vehicles at a checkpoint is invalid because the prior case law must be read as proscribing any stops in the absence of reasonable suspicion. So the fact that you didn't have reasonable suspicion means you can't stop us. They also alternatively argue that the routine checkpoint stops are permissible only when the practice has the advanced judicial authorization of warrant. So, yeah, fair enough. If you don't have reasonable suspicion or you don't have a warrant, you can't conduct a stop. That's a sound argument. Will it work here? We note here only the substantiality of a public interest in the practice of routine stops for inquiry at permanent checkpoints, a practice which the government identifies as the most important of traffic checking operations. These checkpoints are located on important highways. In their absence, such highways would offer illegal aliens a quick and safe route into the interior. Routine checkpoints inquiries apprehend many smugglers and illegal aliens who succumb to the lure of the highways, and the prospect of such inquiries forces others onto less effective routes that are less heavily traveled, slowing their movement and making them more vulnerable to detection by roving patrols. A requirement that stops on major roads inland always be based on reasonable suspicion would be impractical because the flow of traffic tends to be too heavy to allow a particularized study of a given car that would enable it to be identified as a possible carrier of illegal aliens. It would just be too inconvenient to come up with a suspicion. All right. In particular, such a requirement would largely eliminate any deterrent to the conduct of well-disguised smuggling operation, even though smugglers are known to use the highways regularly. While the need to make routine checkpoint stops is great, the consequent intrusion of Fourth Amendment interests is quite limited. The stop does intrude to a limited extent on motor rights to free passage without interruption, and arguably onto the right of personal security. That would be things the Fourth Amendment tends to cover, but it involves only a brief detention of travelers during which all that is required of the vehicle occupants is a response to a brief question or two, and the possibility of production of a document evincing the right to be in the United States. So, papers, please, apparently the U.S. Supreme Court is totally cool with at border checkpoints, even when those border checkpoints are 66 miles inland. All right, that's what they said. Routine checkpoint stops do not intrude similarly on the motoring public. The potential interference with legitimate traffic is minimal, even though it causes the traffic to come to a complete stop. Motorists use these highways are not taken by surprise, as they know, or may obtain knowledge of, the location of a checkpoint and will not be stopped elsewhere. Second, checkpoint operations both appear to and actually involve less discretionary enforcement activity. The regular manner in which established checkpoints are operated is visible evidence, reassuring to lawful abiding motorists that stops are duly authorized and believed to serve the public interest. The defendants note correctly that to accommodate public and private interests, some measure of individualized suspicion is usually a prerequisite to a search or seizure, but not here. For example, see Terry versus Ohio. But the Fourth Amendment imposes no irreducible requirement of suspicion. Suspicion is not a requirement for it to be reasonable. All right. We think the same conclusion is appropriate here, where we deal neither with searches nor the sanctity of private dwellings, or not only afforded the most stringent Fourth Amendment protections. As we've noted earlier, one's expectation of privacy in an automobile and of freedom in its operation are significantly different from traditional expectations of privacy and freedoms in one residence. And the reasonableness of the procedures followed in making these checkpoint stops makes the resulting intrusion of the interests of motorists minimal. On the other hand, the purpose of the stops is legitimate and in the public interest, and the need for enforcement techniques is demonstrated by the case records before us. Accordingly, we hold the stops in question at issue may be made, even in the absence of any individualized suspicion, at reasonably located checkpoints. So, not even reasonably articulable suspicion is necessary. They can stop anyone for just a question or two, or to show papers. We further believe it is constitutional to refer motorists selectively to secondary inspection areas for further detention at the checkpoint on the basis of criteria that would not sustain a roving patrol stop. So, the idea here is let's compare it to a roving officer. So let's just say this checkpoint wasn't here and there was a border agent like in their car or whatever, and they saw the exact same thing. They might not be able to stop the car, but at the checkpoint they can, for some reason. Thus, even if we assume that these referrals are made largely on the basis of apparent ancestry, we perceive no constitutional violation. So even if we assume the reason that people are sent to the secondary inspection area is because of the color of their skin, which might, by some, be considered to be racist, well, that's not a problem here. The Border Patrol can absolutely send you to a secondary area merely because of the color of your skin, and we see no problem in any of that. All right, Supreme Court noted. Other purposes that are served by the requirement of a warrant are not applicable here. What warrant? We don't need those. One such purpose is to present hindsight from coloring the evaluation of the reasonableness of a search or seizure. The reasonableness of a checkpoint stop, however, turns on factors such as the location and method of operation of the checkpoint, factors that are not susceptible to distortion of hindsight, and therefore will be open to post-stop review, notwithstanding the absence of a warrant. Another purpose for the warrant requirement is to substitute the judgment of a magistrate for that of a seizing officer, but the need for this is reduced when the decision to seize is not in the hand of the officer in the field, but rather because of the administrative determination of the higher-ups. I feel comforted in every way. In summary, we hold that stops for brief questioning routinely conducted at permit checkpoints are consistent with the Fourth Amendment and need not be authorized by a warrant, or suspicion, or really anything else for that matter. The principal protection for the Fourth Amendment right at checkpoints lies in the appropriate limitation of the scope of the stop. We have held that checkpoint searches are constitutional only if justified by consent or probable cause of search, and our holding today is limited to the type of stops described in this opinion. Any further detention must be based on consent or probable cause. Further consent beyond the secondary checkpoint. So if they want to conduct an actual search, they need probable cause, but if they just want to detain you and harass you, well, apparently that's totally fine. Thus, that brings us to the end of the case of United States of America versus Martinez-Fuerte. In this case, we learned that it's totally legal and constitutional for the federal government to set up border patrol points that are not near a border. 66 miles away from the border, totally fine. And you can have these permit points, and you don't need probable cause, and you don't need reasonable suspicion, and you can, in fact, discriminate on the basis of race, and that's all totally fine. So this border officer can send you to a secondary inspection for no other reason, and it's not a problem, and you shouldn't have any problem with it, because being asked a question or two and being asked to show papers is of no inconvenience. So, yeah, I don't know what to tell you, except I don't know. Just avoid these border patrol points, because at least they're permanent, so you got that going for you, so you can avoid them. And at least for the moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.